Sarah Wairimu pleaded not guilty in the Tob Cohen murder case as another suspect, Peter Njoroge Karanja, was remanded on Thursday. The High Court in Nairobi ruled that Wairimu remain in custody until the bail hearing for Friday. Karanja, who had appeared for the first time in court, was told that he will be remanded at the Industrial Area Prison. The court further directed that the officer in charge to escort him to Mathare Hospital on Tuesday for mental assessment. His lawyer had earlier pleaded for his release, saying he required urgent medical attention. The advocate revealed that Karanja had been in police custody for 24 days, during which a custodial order was issued by Senior Principal Magistrate Stella Tambo. He further argued that Karanja should not be remanded as it requires a special diet. However, the court noted that the suspect would no longer be in police custody, but in prison where there is a clinic. Meanwhile, lawyer Philip Mugo will continue representing Wairimu after the court noted that he resigned as he is no longer prosecutor. The prosecution then opposed Mugo's plea for bail, saying they cannot release witness statements as they will be exposing identities. These sought 5 days to liaise with the Witness Protection Agency. Mugo responded, saying that they have no objection to them withholding the statements until red action is done, but that's not the reason to postpone the bail application. The court sailed the bail application hearing for Friday, October 4th.
Plenty of time to have compiled any evidence that they have. Indeed, Tob Cohen had a right to life, and those who took it away must be held to account. But for now, I'd like to assure my colleague, the prosecutor, it is not Sarah Wairimu Cohen who is responsible for that money. So it can't be advanced as a reason for denying bail. This case has laid a very bad precedent on the time aspect of it. In fact, from her own words, the case has developed and things have happened. It shows that an accused person was held in order to enable them conduct their investigations, rather than for them to finish their investigations.
If I can, with all due respect to my learned friend, when I was uttering those words, I was responding to his submission, saying that this matter has been taken more than how many days did he say? Yeah, so this is not a new issue that has arisen. It was a response to his submissions. So I'm asking the court to give directions on this because he has no right to reply. And I was answering the court questions on this.
Okay, I was just picking up the point she had made that things have developed, including the one that she mentioned last, that there is a co-accused. The fact that another person has been charged for a similar offense, which we still haven't seen, has no bearing on the matters before us. I don't wish to say more because I don't hold that brief. And I haven't seen who has been charged, what for, and in what circumstances.
Miss, are you saying, Ms. Mwaniki, that you are not able to do replying affidavit? But because you see, I'm listening to you and I'm not hearing the defense complaining that without being served with the redacted statements, they cannot argue the application for bail. That one I've not heard. So why are we talking about it?
For those 5 days, my lady, so that when we are replying or when we are responding to or giving evidence in terms of the compelling reasons, it is important for us to annex the statements, their statements. My lady, if you look at the bail bond policy guidelines, we must prove 1 or 3 issues, or we must prove 1 or 3 things. And one of them would be whether there was interference, whether there is a possibility of interference, whether the relationship between the accused and those people, whether if she would be released, there would be that. In the bail and bond policy guidelines, there are a number of things we would need to prove to the court. And for us to be able to prove, because he who alleges must prove, for us to be able to prove that, we must attach. For instance, even that the offense was serious, we'd have to attach the post-mortem. There are things we need. So we're just asking to be able to give Because if we give them as they are,
I'm not recording this. I just want to understand where you are coming from. When you look at the court order that brought this matter before me, before this court,
yes,
everything was supposed to be done on 26th.
yes,
That is the plea taking,
yes,
the bail application,
yes,
as per the order,
yes,
which is I'm reading here. So, how has the prosecutor used that time?
my lady, that is what.
Because when you look at it, they filed their papers. Mr. Mweupe filed his papers in respect to the bail application. How have you used your time?
Yes, my lady, as even we stated as we came last time before you, in view of what information that we got, for us we did not think those witnesses were persons who needed protection. But when immediately it came to our attention, my lady, we wrote and we informed the court that we have written. And knowing what has happened, my lady, we are therefore not in a position to expose them. But it's only information. And my lady, if you give us time, we'll be able to demonstrate when it happened and why we are in this position. Because we even have an OB report as to that. And then the court and everybody else will be able to understand why these witnesses' identity at this particular time would be jeopardized, or it would be jeopardized.
And my orders here read as follows: that the officer in charge of the remand prison at industrial area shall ensure that the accused is escorted to Mathare Mental Hospital. The earliest date I can come up with is 8th. 8th is Tuesday next week for mental assessment. The same officer in charge of that remand prison shall also ensure that the accused is escorted to Kenyatta National Hospital for medical checkup and treatment, and a report of that treatment filed in this court on or before the date I'll take the plea, which I'll give you just now.
Malady will request then that if he is taken to Kenyatta National Hospital, then his doctor to be able to observe him and attend him at that hospital, because we are saying matters of health are very important. And if someone has stated that he has a condition which the doctor has established with the material before you, it will be then important that Your Honor allow our client's family doctor to see him. For those reasons,
is that tenable in that hospital?
That one is agreeable. I don't think any hospital will restrict a doctor to see his client.
I was proposing,
we have no objection if as you said, my lady, if the Kenyatta National, but the attending doctor will be from Kenyatta National Hospital, then he can be present. The doctors know how they work around that. And I don't know what exactly happens. If there's no problem with that. For us, definitely we have no objection, because it is important that he's treated and for us to proceed with this matter while he's in good health. And a report provided.
If I may add, milady, the condition of our client is acute diabetes mellitus.
Mr. Kiprono, I've pronounced myself.
Yes.
All right, so I propose to take the plea on that Friday, 11th. The 10th is a holiday. So we come back on 11th, assuming he has been assessed or treated, a report filed, then the plea taking on 11th. Yeah, it's a Friday, I know. I'll be the first one not to do it, but sometimes we are forced to sit. So on the 11th is when the plea will be taken. 11th is Friday. That will be in the morning, so you'll be free after that. Yeah. All right. I also want the DR to extract this order so that it is served on the OC industrial area. The other councils now, I seek your indulgence, 15 minutes break. We come back to the rest of the course list. I know I kept some matters aside. Let's uncheck. Mr. Mbui, when I look at it, I'm seeing two substantive or rather prayers you're seeking. One is to enjoin somebody, an interested party, in the trial. I believe that's in the trial. Number 2, the review of the ganging order.
Really, the purpose of joinder is to canvass the issue of the review. That is solely the purpose why.
Yes, it's all right. But are you saying you're not interested in the main trial, just the order?
That order only.
This order is
Yes.
the one you want enjoined.
Yes.
The order was given by my sister,
Very well.
all right? And in my view, she's the right person to review that order.
Indeed.
So the directions I'm giving you in this application is you are going to serve all the parties, that is the prosecution, the interested party, the family, and Mr. Murgu for the defense. Okay? So I'll give you the judge is very busy, but when I consulted on the matter of the date, because I knew that is the direction this matter is headed, she gave the direction that you'll be before her on 15th of this month, in the afternoon, because she's handling that long matter apartheid that is yet to end. And between now and that time, you serve all the parties as I've directed.
We have already served.
Yes, they are also going to put in their responses. Okay, you serve your responses.
Yes.
And you prepare written submissions. So when you appear before Justice Lecit, it will be highlighting. Then you should be able to give to hear you and give orders as may be necessary.
Most appreciated.
Yes.
May I seek directions? You've said 15th before Justice Lecit.
Yes.
Is 15th the day we are coming here also for the application?
What have I said on that application? Is it in tomorrow?
No, hearing of the application for content
Is the same date?
is on the same day.
Why she gave 15th in the afternoon is because of that long matter she's handling. Mine, I'll be able to do it in the morning.
If they want to be enjoined in this matter, they would
Yes.
then need to have gotten directions whether they're being enjoined before we hear the application.
If I hear him correctly,
Yes.
that order seeking and joining that interested party is for the purposes of the order.
Or setting aside the gag order.
The gang order,
Okay.
not
Okay.
the matter
I get
before me.
I get.
Yeah, so I think you can appear before me in the morning, then in the other matter, in the same
afternoon.
application before Justice Lecit in the afternoon.
Okay.
Yeah.
Most appreciated. Thank you.
Reporting for the Kenya Digital News, my name is John Matava.